Hi, I'm Anna Denton-Jones. In this last session in Knowledge November, I'm looking at data protection subject access requests and the potential consequences or risks if you don't comply with the subject access request, perhaps in the way that the individual wants you to. So the first thing that's most likely to occur if somebody feels that you haven't perhaps searched sufficiently for data or you haven't fully complied with your obligations towards them is that you're going to probably receive further correspondence either from them, possibly a trade union representative or a solicitor. And that's got the potential to turn into obviously a series of correspondence back and forth. So it is always worth explaining in full the background to something or why you've done something in a particular way so that the recipient can understand what's going on and not feel that they're just getting a point blank refusal or a refusal to cooperate with them, really, because that can obviously inflame the situation. The second most likely consequence would be that the individual complains to the Information Commissioner. And the most likely thing that you will receive is a letter from the Information Commissioner's office asking you about the background, what's gone on in this particular case. Can you explain to us what you've done and how you've done it? And you obviously have an opportunity at that point to give your side of the story and explain what's been going on. That's probably the place at which most cases stop. The Information Commissioner does have enforcement powers under the legislation and can, in certain circumstances, issue with an enforcement notice requiring you to do something in particular, like disclose a particular document. But more common is probably a request from the Information Commissioner asking you to give certain undertakings. So to give you an example, in 2011 Cardiff County Council were criticised in relation to the way in which they dealt with a particular subject access request, and the Information Commissioner asked them to give undertakings, for example, that they would do some staff training on the subject and that they would have a policy on how they dealt with these things and that they would keep proper records of the subject access requests that they'd had, and then obviously the Information Commissioner may follow up with that organisation later on to check that they have done what they promised they were going to do. There is the possibility of financial penalties being awarded under the legislation, and you will have read about cases in the newspaper where £500,000 fines have been issued. Those cases do tend to revolve around situations where perhaps data has been lost or for example, left on trains and things like that. I don't think there has yet been a subject access request related penalty of that order. What's more usual perhaps would be for the situation to end up in court, because the court can be asked to order, for example, disclosure of a particular document. There was a case recently which fell under that category of suspicion that the individual was just using the subject access request process to seek early disclosure of documentation for the purposes of litigation rather than anything else. And it was interesting that the High Court obviously took a dim view of that person's conduct in that case and weren't prepared to make the orders. There is always that possibility if somebody's being litigious for the sake of it, really, that they get slapped down when they get to court. There is the possibility of a court ordering compensation if somebody can prove that they've suffered damage or distress as a result of your failure to comply, but it is worth noting that the sort of amounts that we talk about there are fairly nominal. We're not talking huge amounts of money. If you do have any questions in relation to any of this series, please do give me a call or an email. My email is adenton@refreshinglawltd.co.uk. Thank you very much.